Good morning again. Last time we discussed Article 124 and Article 125. I have not completed crimes against the fundamental laws of the state. Going back again to Article 124, arbitrary detention. As I have already mentioned, crimes against the fundamental law of the state. Fundamental law is the Constitution, particularly the Bill of Rights. Now, these crimes, as stated in Article 124 until Article 133, these crimes can only be committed by a public officer. Now, going back again to Article 124, arbitrary detention. The arbitrary detention, the police officer or public officer, as the case may be, has the duty to arrest a person if the public officer doesn't have function or duty to effect arrest of a person, then the crime may be illegal detention, the crime that can be committed by a private individual. Now, Article 124, going back again, the offender is a public officer, that he detains a person, that the detention is without legal grounds. Now, you distinguish it to Article 125. Article 125 is delay in the delivery of detained person to the proper judicial authorities. Now, Article 125 is a crime committed when a public officer arrested a person with lawful ground or legal ground for such arrest, and he detains the same, but he fails to deliver that person to the proper judicial authorities. That means if you are a public officer, or in this case, if you are a police officer and you detain the person, you arrested the person, you detain the person at the same time, because you have lawful cause to do the same, you have reason, legal reason to arrest a person, and you know the circumstances which under the law, what are the circumstances that may that you may effect legal arrest on a person without warrant. Now, if you arrested a person and detained a person without a warrant, and you are a public officer or police officer, that two elements under the crime is still legal. You have not committed yet a crime. The essence of the crime under 125 is delay in the delivery of person to the proper judicial authorities. That means if you have arrested a person and then you fail to deliver, or sa simpleng istorya, wala nimo na filean og kaso sa prosecutor within 12, 18, and 36 hours for light penalties. 12 light penalties, depende sa krimen. Ang light penalties, nantaw na nimo ang iyang range sa sa crime committed. Kung unsa iyang penalty mo, na nabilong ba siya sa light or sa correctional penalties, or sa afflictive penalties. Now, dali nga na lantawon ang simple theft, light penalties, homicide, or murder. But to be sure, you have to look into the penalties of the crime for which the person is arrested, so that you can be guided when to file and when the case should be filed in prosecutor's office before the time allowed by law. That's the essence of Article 125, delay in the delivery of person to the proper judicial authorities. We go to Article 126, delaying release. Delaying release na siya order of release. You are public officer, you are mandated to release the person, but you failed to release that person. So, in the essence na I order to release the person from executive or judicial branch of the government. Now, you have the duty to release the person, you are the custodian, and you unduly release the delay the service of the notice, or you just deny the release of the person. Article 127, expulsion. Expulsion is expelling a person from the Philippines or compelling a person to change his residence. Now, the offender, as I've said, in these crimes against fundamental laws of the state is the public officer or employee, and he either expels a person from the Philippines or compels that person to change residence. That is not allowed by law. Now, there is one case before, in the case of Villavicencio versus Lucban. The city of Manila, the mayor of the city of Manila, wanted to make the city free from prostitution. Now, iyang ipadala ang mga, as a, we call it, prostitutes from Manila, iyang ipadala sa Davao. Now, ang iyang intention is to free the city of Manila daw from the prostitution. In that case, he is a public officer and he expels a person without authority from the law. Now, how can you expel a person? Or was there a law allowing you to expel a person from Philippines or from his residence? Was there an exception to the provisions of Article 127? You have to look for that. We continue on Article 128, violation of domiciles. What are the acts punished under Article 128? 1. Entering any dwelling against the will of the owner. 2. Upon entering the dwelling, searching papers or other effects found therein without previous consent to the owner. Or 3. Refusing to leave the premises after you enter the premises, having surreptitiously, that's secretly, entering the said dwelling, and after having been required to leave the same. What are the common elements? The offender is a public officer or employee. He is not authorized. Number 2, he is not authorized by judicial order or executive order. No, judicial order only, to enter the dwelling or to make search therein for papers or other effects. Now, the circumstances qualifying the offense is that if the same is committed during nighttime, if any papers or effects or constituting evidence of the crime are not returned immediately after the search made by the offender. The qualifying circumstances means that the penalty for the crime is higher, or there is a higher penalty for the crime committed if qualifying circumstances is or are present in the case. Now, I have mentioned in messages the difference between trespass to dwelling and this Article 128 of the Revised Penal Code. Trespass to dwelling, private person, public officer, and Article 128. Now, you have to be familiar now with the provision on the Bill of Rights that no person, no life, liberty, or property shall be, or no person shall be deprived of life, liberty, or property without due process of law, and no search warrant or warrant of arrest shall be issued except upon the order of the judge, upon examining the witnesses, etc. You have to be familiar with that now. Article 128 penalizes the violation of your right not to be searched in your home. It is your right. If it is your house, no one can enter that house without your permission, especially the agents of the state. No one, except upon search warrant issued by the judge. So, if a public officer enters a dwelling against the will of the owner, that's violation of under Article 128. If public officer search papers or other effects found in your house after you, say for example, voluntarily and willingly let him inside, then that public officer still commits the crime under 128. If the public officer, after you told him to leave, he refused to leave the premises, after he secretly entered your dwelling, that's the crime punishable under 128. Now, as I've said earlier, the common elements of this crime, there are three acts that may be committed under this provision, as I told you already. Now, the common elements is public officer or employee, and he entered the dwelling of another without court order. That's the essence of the crime. Now, if you are a police officer, or if you will be a police officer later on, you have to learn the fundamental rights of the citizens, and you have to respect them. You have to be mindful of the rights. You have to see to it that a free man cannot be just subjected to search and seizures of their property without due process of law. You have to respect the house of an individual citizen, even though you have a strong suspicion that the illegal items can be found therein. If nakaiduda nga na ay mga illegal nga buhat diya, then you apply for search warrant. That's the legal, lawful way to validate your suspicion.